Call to the public. Those wishing to address the Central Yavapai Fire District Board need not request permission in advance. However, we ask that you complete a call to public form for the record. The board is not permitted to discuss or take action on any item raised in the call to the public due to the restrictions of the open meeting law. However, individual board members may be permitted to respond to criticism directed to them. Otherwise, the board may direct the staff to review the matter, or the matter may be placed on a future agenda. Individuals may be limited to speak for 3 minutes, with a total of 30 minutes allotted for call to the public per meeting. Do we have any? No? Okay. Consent agenda. All matters listed under consent agenda are considered to be routine by the Central Yavapai Fire District Board and will be enacted by one motion. There will be no separate discussion on these items. If discussion is desired, that item will be removed from the consent agenda and will be considered separately for discussion and possible action. Does anybody wish to? Director Still.
Madam Chair, which way, off, on, okay. I'd like to pull item A, item B, and item E, Edward.
Is there a motion to approve the amended consent agenda minus items A, B, and E?
So moved.
Second.
All in favor?
Aye.
Aye.
Aye. Okay. The amended consent agenda is approved. Okay, go. Consent agenda item A.
Madam Chair, board members, I have the same explanation for A and B, and that is that the last two meetings, in particular the last meeting, I asked for a copy of the audio tape so I could review it because it went very quick. And as you can see, I wear hearing aids, but the sound has been not to where I've been able to understand portions of what has been discussed. So for that reason, for me, that's why I'm asked these two to be pulled, because I cannot approve them based on my recollection of those meetings and the minutes provided. I saw the minutes provided, but it still was not adequate for me. So that's my statement.
Madam Chair, also, I'm in agreement for pulling the consent agenda items A, B, and E. First of all, on item A, approve the general for the regular session minutes and the executive session minutes. After reviewing them several times, I noticed that it wasn't as accurate as I would like to see, especially in the executive session. And there were things that were mentioned by the attorney that was not recorded as being part of the executive session minutes, in which, being that it was executive session, it would be inappropriate for me to discuss that now at this time.
Mr. Attorney, would you like to address these issues?
Sure. So Director Steele and I communicated at some length regarding the issue related to review of both open meeting and executive session minutes. And the issue is that with regard to those things, he requested that a copy be made so that he could remove that from the facility and review those things at his leisure at home. And the difficulty with that is that in particular with regard to executive session minutes, there are confidentiality clauses which have an impact on that. So the process that I followed was to go to the open meeting law enforcement team unit at the Attorney General's office, and that took some time because the individual I'd previously spoken to in that unit had transferred to a different section. So I worked my way through all of that, and I ended up speaking to an individual there at some length, discussing the facts and circumstances, and I would advise that There is no previous instance where that has ever taken place, where anybody has been allowed to make a recording and leave with it. Obviously, any director can request to come into the office and review those things as many times as necessary and take notes. And that was the advice that I was given. So that was the advice that I provided to Director Steele when he and I were discussing this issue. Same thing regarding open meeting minutes. I think that it's perfectly appropriate for a director to come in, review those. I think any member of the public can come in and review those recordings as long as the agency has them. Executive session, obviously only directors, but here at the agency, review them, make notes, provide information to myself or to regarding what changes or additions need to be made, and then I think that can be done. I don't necessarily think that it should be delayed months and months. I think it needs to be done fairly rapidly, just so that we can move forward with the record and we don't have things hanging around. So I would suggest that directors try to do that within the month following the issuance of those minutes for approval, so that any changes can be included on the next monthly meeting. That's my suggestion. It's not necessarily a legal requirement. Keep in mind that by law, the public records law provides we can keep recordings for 90 days and that's it. I don't think we want to wait the full 90 days. If we do that, we're going to be stacking up minutes over time. So I would say try to get it done by that next meeting if possible, if not possibly the meeting after. I don't think it should go any 90 days. So haven't really discussed that particular, but I think it's important that directors have the opportunity to review these things. I just don't want it to delay the ordinary course of business for the agency. So,
Well,
Just a process question for you, Nick. Anyone can record these meetings on their own, correct? The public?
Can sit out there with a recorder and record the open meeting session if he or she wishes to do so.
I could bring my own recorder in also and
You could.
hit record
Yes, absolutely.
and leave with it,
I
not the
think so.
executive.
Not executive session, but open meeting. And that's why I said that I think any member of the public could request to review the open session minutes and the actual recording thereof. The difficulty becomes when we're talking about the executive session portion. As far as the executive session portion, I was strongly advised that their confidentiality requirements dictate that they should never leave the agency. That's what they said. And I said, are you aware of any cases where this has been analyzed? And he said, no, I'm not aware. And the way this worked is I left him detailed voicemails, he left me detailed voicemails, checked with senior staff, and then he and I actually spoke for probably 35 minutes to really hammer through the issues. I then followed up with the State Bar in overabundance of caution, not because they're open meeting experts, but just to make sure I wasn't overstepping by making this suggestion to the board. So I feel it's been fairly thoroughly vetted. My initial reaction was it should be that way. I know that Director Steele and I, we had some backwards and forwards, that is, we exchanged some emails and had some phone calls about it. But that's the advice that I've been given, and I'm not inclined to suggest otherwise.
2 points. One is, I read the statutes also, and it didn't say I couldn't. It just said it had not been done prior. And my original comment was, I wanted to bring my own recorder in and my own blank tapes, so I wouldn't be taking staff time to do it, or even the additional cost of the tape. I would just merely record it. And as a sworn board member, I'm sworn to the oath of protecting the minutes in executive session as well as open session. So I take the opposite approach and say, yeah, I should have had permission to do it right then, and then I could have been here and I could have overcome my objection and I could have potentially approved the minutes that were set forth tonight. That's my comment.
Any other?
I have a question. How is video quality?
Not video, audio.
I know, but video quality, since the, meetings are recorded, I was just curious how, if that's ever attempted.
I wasn't concerned.
Well, just for audio as well, were you able to hear anything from the video?
I didn't attempt to look at the video.
Okay.
Any other discussion? Is there a motion to approve the regular session minutes and the executive session minutes?
Madam Chair, is it possible that we could go ahead and just remove this and bring it back the following following month on December the 21st that would allow Director Steele to, I had really bad bronchitis and I didn't even have a voice, so I couldn't even come in to review it. But I have time now and I'm feeling much better, that I would be able to come in timely, to come in and to view the executive session especially.
Madam Chair, noting that, I'd move to table items A and B from the consent agenda for the next board meeting.
All in favor?
Well, there needs to be a second.
I'll second.
All in favor?
Aye.
All right. Item E, transfer October revenue from Central Yavapai Fire District and Central Arizona Fire and Medical Authority in the amount of $6,272,359.79. I'm going to make a motion that we approve this transfer.
I ask that it be pulled, Madam Chair,
I know.
for discussion.
I made a motion that we approve it.
For a motion.
You know,
That's fine. If that's what she says, that's fine. Let her do what she wants.
technically, I think that it can be moved and seconded, and then discussion can follow.
Yeah,
If that's going to take place, if anybody offers a second.
that's fine.
Alternatively, we can discuss it in advance of the motion. It's entirely within your discretion.
I'll second.
Discussion? Well, I'd like to start and ask Attorney Cornelius, would you address the legality of this vote and what our fiduciary responsibility is?
You know, first I'd like to just have an understanding what the basis for the removal was.
Director Still? What was your objection?
My objection is, as it's been in the past, that the Central Yavapai Fire District has very little discretion in all this money is being spent. And as being one of the two people that are not accessed, and by the way, I did not receive a copy of the agenda for for CAFMA or for Chino Valley. I had no idea what they were going to be discussing tonight. And also, being left out of all those major purchases kind of makes me feel a little on edge. Being asked to transfer over $6 million this month, and yet, is that all we're good for now? So that's my reason for voting nay or abstaining, if that is a better legal answer for you, Mr. Cornelius.
Okay, so I can address some of those things. I was just advised by the chief that the agendas for the other two were attached, so I'm not sure.
They were not.
No, they were not.
They were not in my envelope, and neither were the department reports.
Right. We did not.
Division
put that on
reports.
our-
I think Laura's going to take a look and see
Yeah.
what happened.
Well, you can see
Did other
my,
board members get those?
You can just look at the
No.
report I have.
well,
We don't get.
they're on
Chino.
CAFMA.
You guys don't get Chino,
They're-
so nobody gets Chino.
Actually, no.
We used to.
Well, hold on.
We used to.
On November 21st, I received a letter, email from Laura. This had every agenda on it, as well as the division report and the capital replacement schedule. Sent to board members by blind copy, November 21st, 2017 at 10:10 a.m.
And who are the board members listed on that?
It doesn't say
It
because it was
doesn't
blind.
say.
so she's looking it up.
I didn't get that.
She'll look it up on her original, but go ahead.
Yeah.
So, you know,
Does
that's,
someone come look at this? Does someone need to
sure,
come look at
excuse me
this?
one sec, let's see.
This is the email that she
Come
sent.
here one time.
Well, I don't want to get on
Got
this.
it.
No, I don't get on this.
Okay, so let's go back.
Did you?
All right, so I'm looking at that same email, 11/21/2017, 10:41 a.m., and it lists Packard, Wasowitz, Zurcher, Steele, Jacobs, Ducote, Dobbs, Pettit, Mayday, League. So that's everybody.
Yep, and where's all the documents?
That was the agenda for this meeting?
All the agendas, yeah.
Well, we got our agenda.
No, there's all of them on there.
All
Chino
we got was
Valley,
ours.
Central
You can look
Yavapai,
at my tab.
CAFMA, the capital replacement schedule documents, and the division reports sent to everybody.
No.
And to myself, Department Freitag.
That's what mine says too, it doesn't have that.
Yeah, all I've got is Central Yavapai Fire District Board of Directors.
On the November 21 email?
Yeah, we got that because she was having a glitch in the system, and I sent her an email and
Central
said that I
Yavapai,
got
Central Yavapai, Central
the
Yavapai.
CYFD.
Yeah, that's separate, but I'm thinking,
That's what
if we take a look down here.
That's
so
draft
there's
minutes.
Minutes,
That's-
minutes, yeah, it's not in there.
And here's November.
Yeah.
And that's all we get for November. Because usually it's
So,
listed here.
did you, do the
We got it
emails
last
show up
month.
on the iPads?
Well,
Okay,
in
so
their
it's not-
email, not in board pack, in their, the,
Oh, in your CAFA
Outlook.
emails, okay, so not in
You
Word.
have to go to your email to get those things.
Like we do every month, put it in the board
Just
pack
an
like they did
email.
last month. See,
It's in
last
Outlook.
month you got all of them. But they didn't put them in the board pack this month, they put it in an email.
We put them in the board, pack. They don't ever put it in the board pack.
It's always a.
It's always a separate email.
Okay.
It shows in the board pack right there from last month.
Don't say it always that way, because last month it was in our
We got
board
all
pack.
three of them. Okay, that's my email. That's fine.
Maybe because I'm looking at mine and it has all three.
But that's
But
because
I
of
have
your,
the email
you're the
because-
attorney.
I'm the attorney, and I see that Packard has two. So if we're talking about the old ones, it's because maybe that's an update and it posts to everybody? No? Okay. Because if we take a look at Director Steele's, it does have them for October.
It does,
In
but
board
not
pack.
for this month.
Yeah,
You're talking the meetings, you're not talking the email.
that's correct.
The email has all your agendas and your division report every month.
Okay.
So you have to go to your email. to look at it.
So I got it on my
Last
email.
month was the test.
Even though
where
it
it
has
had
been
Chamber
changed.
Valley stuff.
So those are going to the agency email.
They always have.
Okay, if you say so.
So resolve that piece, so you have to check your agency emails. As far as some of the other issues you raised, there's just a couple of points. I mean, I've addressed some of this in correspondence to Director Steele and Director Jacobs, who voted no at the last meeting. So there's a couple of things going on with that. An abstention is probably better than a no vote, legally speaking. But you should exercise your own discretion. The reason I say this is because factually, I disagree with your analysis. I think that when this board conducted an evaluation of the budget and approved the budget, that's the opportunity to do that. That's when those things happen. What's taking place during the course of the year is simply implementing the budget that was previously approved by this board, in the same way with the Chino Valley. So I disagree that all you're doing is moving money, because at the time of the budget, it's when those things would have been decided. But having said that, the issues related to a no vote are that I think that creates a substantial legal problem for the agency. I think that it creates a problem for CAFMA if it doesn't have the funding that it's required to do, because the funding is what it uses to provide fire and emergency services. So if the funding is delayed, first you're in breach of the contract, and I think that's a breach of fiduciary duties if you do that. Second, I think it creates problems for all of the things that get paid with that money, including, for example, employee salaries, workers' comp and other health insurance benefits, the PSPRS payments, payments to outside vendors, rent, utilities, fuel, all of those things. So I think it's dangerous and creates a potential risk for the agency. I think it also creates potential risk for individuals were they to vote that way, because you may be taking yourself out of your qualified immunity by engaging in
Okay,
that.
Mr. Cornelius. I voted against the budget. I'm not sure if board member Jacobs did also. But I think it was passed 3-2. Were we in violation of the law for voting against that, the budget?
I beg your pardon?
Were Director Jacobs and I in violation of the law for voting against the budget because we didn't approve
No,
the 4.5% increase?
not at all. Not at
Well,
all.
then why are we in opposition to that if we vote now as a matter of conscience for the taxpayers of this fire district?
Because the budget was approved by the agency by a majority vote. Contracts have been put in place, and that's where the liability arises. It's a function of contract, sir. when the contract was signed, and as I recall, both of you signed the original CAFMA contract. I think even Director Jacob
No.
moved for it to go in. So when the entity was created, there's a contract between this agency and the CYFD to provide funds so that fire and medical services are provided in both districts. If that is unfunded, if there's some vote taken in violation of the terms of the contract, that's where the problem arises. It creates liability not only to the individuals that are getting direct payments, that is vendors, employees, and all the rest, but it also creates problems with the state and the federal government that oversee wages and hourly payments. There can be liabilities that arise whereby it's not only the amount that people were supposed to be paid, but sometimes twice that amount or 3 times that amount in penalties if they don't receive those payments. That's separate and apart from any breach of contract on somebody would have. So I think that obligation is different when the contract is in place. The budget has been approved by both agencies, whether there was a no vote at the time or not, to say that now that the money is up to be transferred, we're going to vote to hold that up. As I think I've mentioned, I don't think it's an issue when there are other board members that approve it. My concern is if there's a situation where that doesn't arise and there's a no vote and money isn't transferred, then liability will accrue right at that moment, no question. So I think it's important to get that out and be completely clear about it. This doesn't mean you can't change the actual contract. And I know that there's going to be a discussion about that. If the board agrees to go forward with that, then there's a discussion with the CVFD and see if they agree to those changes. If they don't, then it is what it is. And either you look for breaching the contract entirely to walk away, or it stays in place and we're bound by the terms of the agreement, the same way we are with any other contract that we sign.
Point is still taken that a 3-2 vote is still going to approve that $6,200,000 plus transfer to capital. Okay? So I'm making a personal vote because my duty is still to the fire department and to the taxpayers of Central Yavapai Fire District.
I understand, sir.
Okay, thank you. I'm done.
Attorney Cornelius, I disagree with your legal interpretation, and I'm not going to be intimidated by your legal intimidation. I am going to vote no, and I will continue to vote no until we get some resolve that we've been asking for since the inception of CAFMA.
Very good.
All right, I'm calling for the vote. All in favor to transfer the funds? Signify by saying aye.
Aye.
Opposed?
No.
Abstain.
Motion carried. Vote to go into executive session. Do I have a motion?
So moved.
Second.
All in favor?
Aye.
You all may stay, and we're leaving. Regular session. Old business. Discussion and possible action related to training gutter drainage issues. Attorney Cornelius, you have your direction?
I do indeed.
Okay. Item B. Discussion and possible action related to board size and appointment under the CAFMA Joint Powers Authority and possible changes to the related intergovernmental agreement. Director Jacob.
I believe Director Steele was the one that's spearheading this.
All right, Director Steele.
Yes, Madam Chair, board members, yes. There was circulation of these documents, I believe, a little over 3 pages. Each one of you have had a chance to look at them, but just for the public's knowledge, it's the concerns of the validity of the Joint Powers Agreement as it pertains to ARS Title 48, Chapter 5, and recommended changes to the Joint Powers Agreement. Under Section 1, creation of the authority, the parties CYFD and CVFD boards have created a separate legal entity known as the Central Arizona Fire and Medical Authority, CAFMA. It was our understanding that CAFMA was going to be a management oversight of the fire districts, or as it was explained, an umbrella over the 2 fire districts. This would only require 1 fire chief, 1 human resource manager, and allow the shuffling of battalion chiefs between the 2 fire districts to save personnel costs. We never anticipated that two fire districts were going to be dismantled and combined in their entirety into CAFMA, or that fire district board members who were not on the CAFMA board would be stripped of their autonomy under ARS 48805. It is our belief that ARS 48805.01 does not allow the consolidation of the CYFD and the CVFD into one organization, CAFMA, without first getting the approval of the citizens of the fire districts by conducting an election as outlined in ARS 48-802.F&G and ARS 48-820 and ARS 48-822. The only reason we voted for this process was to save money. However, the unforeseen consequences in the consolidation of both fire districts now promotes us to reconsider our decision. We cannot understand how two fire district boards can exist when they have no fire district to oversee, since the personnel, equipment, facilities, property, PSPRS retirement payments, insurance, workman's comp, and so forth have all been transferred to CAFMA. So in essence, voters are electing fire district boards that have no fire district, and at least 5 board members are stripped of their autonomy under ARS 48-805 and merely pass money to operate CAFMA without being allowed any operating oversight as outlined in ARS 48-805. I break there. I guess if there's going to be any questions or any discussion.
Just a quick question, Tom. This, it says "we." Who's "we"? I didn't see a signature on the end of this or a
Well,
signature block.
Actually, we have that I wrote on here for an amended copy, authored by Tom Steele and Vicki Lou Jacobs.
Okay, thank you.
It was a joint research effort.
We
Both
took
of
a
us.
significant amount of time, despite my bronchitis illness, it took us quite some time to get through this. All right, under section 1A, nature of the authority. This section clearly states that the authority is a separate legal entity organized pursuant to the ARS statutes 48-805.01. It also states that the authority will observe and comply with the statutes and the laws applicable to the fire protection district. Does this include conducting the election to get the approval of property owners in both fire districts as outlined in ARS 48-802F&G, ARS 48-820, and ARS 48-822? In the Fire Chief's Fire Division report on March the 21st, 2017, he states, our intergovernmental agency or agreement and accounts have been vetted by our legal counsel, the county attorney, several assistant attorney generals, as well as others. Based on their findings in concert with relevant statute, no legal issues exist relating to the finances of CAFMA. We are requesting that you identify the names of the aforementioned legal authorities who provide their opinions and findings due to our issues of concern brought forth in this document. I know personally I've been asking for that for months, and I still yet have not received it in writing.
Under section 2, governance. The board of directors of the authority. The governing body of the authority shall be appointed board of directors in which all administrative and legislative power of authority is vested under ARS Title 48, Chapter 5. Based on this provision, the 5 board members not assigned to CAFMA are stripped of their administrative and legislative power under the authority. Under subsection 2A1, number, the board of directors shall be comprised of 5 directors. Each director shall be entitled to cast 1 vote on any matter that comes before the board. We believe this section should be revised to 7 directors based on provisions in ARS 48-803, which allows a fire district that exceeds 50,000 in population to have a 7-member board. Since CAFMA has just under 90,000 in population, they should go to a 7-member board that is represented by the 2 fire districts based on the percentage of budget and population. This is founded on appropriate representation based on taxation principles. Since CYFD contributes 84% of the budget and 80% of the population, they should have 5 directors for CAFMA. Since CVFD has contributed 16% of the budget and 20% of the population, they should have 2 directors for CAFMA. This would equate to 70% representation for CYFD and 30% for CVFD. The current fire chief believes that CAFMA board should represent a partnership between the 2 fire districts, and we wholeheartedly, respectfully disagree with his assessment.
Under subsection 2A2, appointment. Based on the appointment process, each of the 2 fire districts submit their chairman and clerk as representatives. They in turn elect the 5th member from the fire district that makes the largest financial contribution to the JPA. This has not been followed in the past and continues not to be followed since the Chino Valley Fire District Chairman has never served on CAFMA board. Why have you failed to follow your own policy? There also should be some latitude to rotate all district fire board members to ensure that they have served on CAFMA board at least half of their term, if they desire to serve. This action could resolve the matter of stripping fire district board members who do not serve on the CAFMA board of their autonomy. The current CAFMA board appointment process disenfranchises the voter in both fire districts because the person or persons they are voting to oversee the fire district may be stripped of their autonomy and have no power to administer the provisions of ARS 48805 if they are not appointed to CAFMA. Another consideration would be to create a district system similar to the Yavapai County Board of Supervisors to ensure that the voter has representation on CAFMA. The current CAFMA board has 2 directors from Chino, 2 from Prescott Valley, and 1 from the Dewey-Humboldt area. There is no director to represent the Prescott addresses in the county islands located within the county, which could be as many as 25,000 in population.
Under subsection 2.3, removal, the JPA allows a director to be removed from CAFMA with or without cause, whenever it is a judgment of the best interests of the authority will be served thereby. Why would a director be removed from CAFMA without cause? Under subsection 2C, duties of the board, duties of the authority board of directors shall be set forth in the authority board policy manual as amended from time to time. The CAFMA board has never developed a CAFMA board policy manual and is currently using the CYFD board policy manual. Fire chief's contract requires him to update policy matters to ensure compliance. Under subsection 2D.2, removal, we would question whether someone would be removed from the CAFMA board without just cause.
Under subsection 4, assignment of assets, debts, property, and personnel. To carry out the authority's obligation to provide fire, rescue, and emergency services on behalf of the parties hereby assigned to the authority beginning July the 1st, 2016. Their assets, debts, if any, property, and personnel are as more specifically provided in this Article 4, based on provisions outlined in ARS 48802 F and G, ARS 48820, and ARS 48822. We are unsure that the 10 fire district board members have the authority to enter into this agreement without conducting the election to get the approval of the property owners in both fire districts. Under subsection 4A, assignment of existing assets and debts. As previously stated, based upon the provisions outlined in ARS 48802 F and G, ARS 48820, and ARS 48822. We are unsure that the 10 fire district board members have the authority to enter into this agreement without conducting the election to get the approval of property owners in both fire districts. Under subsection 4B personnel, as previously stated,
If I may, Director Jacobs,
excuse me,
let me just answer your question regarding 48,
can we
820.
wait for me to finish?
No, I want to address this one because you've said it several times. Regarding 48, 820, and 48, 822, those refer specifically to consolidation or merger.
Okay,
This-
well, we've consolidated based upon you. There
This
is no
was-
resemblance of a fire district from Central Yavapai. Do we see a fire truck with Central Yavapai? Do we see a fire station? And where's the personnel under our budget?
Please allow me to finish my comment. 48, 820, and 48, 822 are specifically related to consolidation or merger. This is a separate statutory entity. There are multiple joint powers authorities statutes in the Arizona Revised Statutes. They appear in all of the special taxing district sections. They appear in multiple other sections. The same language that appears in this particular statute is cloned in all of those other JPA sections. This is a standalone legal entity. It is not a consolidation or a merger.
It is a consolidation.
Well, I think we're going to have to agree to disagree because legally
Yeah.
it is not. And your questions arising from you're unsure whether the boards had approval to do this, statutorily, they absolutely did.
I
There is-
disagree with that.
You're
Now that
mistaken.
we've
You're
come this
mistaken.
far.
The fact is that they have absolute authority to create an entity under 80501. No question at all. With regard to how it's operated, with regard to how board members are appointed, those are all issues that are open to discussion. Could it be created in this way? No question. Anybody who disagrees, there's a process called a declaratory judgment action, and they can go forward. And I'm here to tell you, we'd be happy to take that step, and this agency will be happy to pursue its attorney's fees and costs for having to address that specious argument. So let's move on to the next piece. Is an election required? Under 80501,
Excuse me?
absolutely not. Absolutely not. And let me be clear, the statutory sections related to 820 and 822 requiring an election used to be only if there was a non-unanimous vote. In other words, it was a two-step process. Unanimous vote or election. That statute has been changed. It no longer requires a unanimous vote. In other words, under 820 or 822, if a majority agrees to do it, it no longer requires the election. That issue is past tense. It is not a legal basis for arguing that the creation or organization related to the JPA is in any way illegal. And I'm tired of going backwards and forwards on this because people keep saying it. There is no basis. If you think there's a basis, file the suit. We'll have the discussion in front of the judge and we'll collect our attorney's fees and costs thereafter. That's my position, legally speaking, related to that issue. Thank you.
With respect to your position on this matter, I'm going to go ahead with my position. Under subsection 4B of personnel, as previously stated based on the provisions outlined in ARS 48802 F and G, ARS 48820, and ARS 48822, we are unsure, and I stand by this, that the 10 fire district board members have the authority to enter into this agreement without conducting an election to get the approval of the property owners in both districts. Under subsection 4B1, Fire Chief, prior to the creation of the authority under the IGA, the CYFD board had oversight of the Fire Chief as their only employee. Under the current agreement, only the CYFD board members that are appointed to CAPMA have the authority. Therefore, those board members that are on CAPMA board have supervisory oversight of the fire chief for performance evaluation, pay increases, and etc. Consequently, 5 elected board members are stripped of their autonomy based upon the provisions outlined in ARS 48802 F and G, ARS 48820, and ARS 48822. We are unsure that the 10 fire district board members have the authority to enter into this agreement without conducting the election to get the approval of property owners in both districts under subsection 4C, pension funds. Based on the provisions outlined in ARS 48802 F and G, ARS 4820 and ARS 48822. We are unsure that the 10 fire district board members have the authority to enter into this agreement as well without conducting the election to get approval of property owners in both fire districts.
Under subsection B.A, creation of a single integrated fire authority. Based on provisions outlined in ARS 48802 F and G, 48820, and 48822, we are ensured that the 10 fire district board members have the authority to enter into this agreement without conducting an election to get the approval of the property owners in the districts under subsection B and D. Transfer of authority in CYFD assets, property, personnel, and pension funds. Based on the provisions in ARS 48820 FG, 48820, 48822, we are ensured that the 10 fire district board members have the authority to enter into this agreement without conducting an election to get the approval of the property owners in both fire districts under subsection VE. Transfer of authority in CVFD assets, property, personnel, and pension. Section VE, transfer of authority in CVFD assets, property, personnel, and pension funds. Based on the provisions outlined in ARS 48802 F and G, 48820, and 48822, we are ensured that the 10 fire district board members have the authority to enter into this agreement without conducting the election to get the approval of property owners in both fire districts. Under subsection 7, terms and termination, term and termination A. Term based on provisions outlined in ARS 48802 F and G, 48820, and 48822, we are ensured that the 10 fire district board members have the authority to enter into this agreement without conducting the election and approval of property owners in both fire districts. Under subsection 7C, future consolidation with non-party expansion of agreement to others. Based on the provisions outlined in ARS 48802 F and G, 48820, and 48822, we are ensured that the 10 district board members have the authority to enter into this agreement without conducting the election to get approval of the property owners in both fire districts.
Under subsection 8, miscellaneous, A, party inclusions and exclusions. Based upon provisions outlined in ARS 48802 F and G and ARS 48820 and ARS 48822, we are ensured that the 10 fire district members have the authority to enter into this agreement without conducting the election to get the approval of the property owners in both fire districts. And in closing, at the time the JPA was approved by CYFD and CVFD board members, we were told by Attorney Cornelius, who represent all three boards, that this was a new animal that has never been done in the state before, and we can make changes as we go. Therefore, these are recommended changes to the JPA that should be pursued for consideration. However, before these changes are pursued, we would like to conduct the required election as outlined in ARS 48802 F and G, so our constituents will determine the direction that we take for the future of CAFMA. And this document was authored by Tom Steele, Director of CYFD, and Vicki Lee Jacobs, Director of CYFD, and I have a closing statement. As an elected official, I took an oath to uphold the Constitution and the laws of the state of Arizona. That is what I'm doing here today. And once again, I continue to bring forward concerns surrounding the formation of CAFMA and how it relates to state law. As it stands currently, all taxpayers in CYFD will continue to have tax increases to support CAFMA while Chino Valley Fire District tax levy is at its maximum and will not see an increase to support CAFMA. Central Yavapai Fire District and Chino Valley Fire District taxpayers have been disenfranchised and never have had the opportunity, according to the Arizona Revised Statutes, Title 48, Chapter 5, to conduct an election so that taxpayers can have a vote to consolidate the two fire districts. Chief Freitag has said, with Attorney Cornelius being present, he knew the taxpayer would never pass it. So this is what we're going to do. I continue to question Attorney Cornelius as representing all three boards. That's nothing new to him. I've got emails to support that, and feel as though we were deceived by not informing the board members at the April 26th meeting, April 2016 meeting, the provisions in the law that requires the vote of the taxpayers. The 10 board members do not, and I repeat, they do not have the authority to vote to disenfranchise the taxpayers their right to vote. And I'm standing with the taxpayers. And every one of these firefighters that are in here, they also are the taxpayers within either one of the fire districts and could be financially responsible for it as well.
I'm calling for a motion.
Before you do that, I want to address the issue related to the vote. This all seems to arise, as I see it, from an analysis which is mistaken, erroneous from the get-go. You're characterizing a statutory provision enacted by the legislature in multiple sections as something which it is not. You're claiming that it's a consolidation or a merger. It's neither. The
Can you
requirements-
tell me, Attorney Cornelius, where is CYFD Fire District? Where's our personnel? Where's our fire stations? Okay?
It's the
Where-
same.
No, you consolidated under CAFMA.
We didn't. A consolidation would be an entirely different entity. A consolidation would require the disappearance of one fire district entirely to be subsumed in the other, and one of the boards would be completely dissolved. It would go away entirely. In a merger, the boards actually become a combined entity, and some portion of those board members are actually disenfranchised, that is, removed. As an elected official of this agency, you're authorized to review the budget, you're authorized to review changes to the policy manual, you're authorized to review purchases, transfers of funds, all of those things are within your purview. There has been no disenfranchisement, and I want to point out, there were 3 board members here today who were present when this thing was put in place, and you all voted.
They were not present. They were not on the board.
You were on the board.
I know I was on the
Steele
board,
was on
and
the
you
board.
know as
Packard
well
was
as I
on the
do,
board.
I've had questions from the inception. You and I have had
But not about
detailed
this.
Oh, yes, we
Not
have.
about this issue.
Oh, yes, we
What I'm
have.
hearing today is a request to change the board to comport with a statutory section which doesn't apply. And, let me finish, and a suggestion that if the board was changed in its composition, that would resolve your concerns. I'm not sure how that happens. If on the one hand, if the board didn't have the authority to do this and you're unsure about it, how does changing the composition of the board at CAFMA impact that in any way? That's first. Second, there has always been, from day one, there isn't a single day that CAFMA hasn't existed when the CYFD has not had a majority on that board. Every single day. CYFD has had a majority on that board. No question about that at all. So what you're talking about is changing the board makeup. That's something that the board can address if it wants to do it. Keep in mind, it's a contract with another party. They would need to agree as well. So if this board agrees to go forward, perfect. Give me instructions and I'll go have the discussion. If you feel there's a conflict, as I've stated on many occasions, and as I stated during that whole process, I put my concerns about any potential conflicts in writing, and it was signed by this agency and by that agency with regard to moving forward. As the JPA provides, in the event there's a conflict between the two, I no longer represent Chino Valley. I represent this entity. That resolves that concern outright. If you think there's something else, as I've asked many times, and as I got no response, tell me what your concerns are, and if there's something further that needs to be discussed, I'll be happy to do that. That too is in writing, Director Jacobs, and I've got exactly 0 in response to that. Questions about the attorneys that approved this agency? They didn't approve it. They took a look to determine, are the plans with regard to the financial structure appropriate? Are they admissible and acceptable under law? That was through the county attorney's office.
And as you know, I've been requesting the
I
names
have
of
no
those
idea who that
individuals.
person's name was.
But you had conversation.
I didn't have
Well,
conversations.
then how can you say that this has been vetted then? If you
Because I
didn't
have
have
conversations
conversation.
with the people at the Attorney General's office who represent PSPRS,
Okay.
the workers' comp unit.
So you didn't
issues
go to the
related
AG's office or any other governmental
To be
agency?
clear, the AG's office has taken the position with me in verbal communications and in writing. We don't represent fire districts, we will not opine. And as an aside, I learned earlier today that 2 District 1 representatives actually filed a written request in May of this year for the Attorney General's office to opine. I've been told many times, I understand Director Steele has had conversations as well, they will not opine. they're not going to do it. So if somebody wants to pursue it, there are legal methodologies for doing that. There's no reason for us to be spinning our wheels. There's no reason for you as directors to have any sense that you're unsure whether what's taking place is correct or incorrect. Follow your legal obligation,
That's what
follow
we're
your
doing.
legal rights, and proceed. That's how you do it.
So from you saying that then you are not in agreement to allow the taxpayers, for this
It's-
to go to the vote to the taxpayers?
It's not a question of agreement. The law does not require it.
Okay,
If what you're
that's all I
saying
need
is,
to know.
well, let me finish. If you think that there is a basis for proceeding in that way, the things that you have represented today legally do not require that. So if you want to go forward with that for the taxpayers, so that the taxpayers understand, it's tens of thousands of dollars to go forward with an election first. That's in each of the separate fire districts, which means you're not only trying to bind this entity, you're trying to bind that entity. Secondarily, there are substantial delays. I don't think there's any basis for going through that process without a finding, say, from, I don't know, a judge, that the entity is in fact problematic. So there are ways to pursue it. I think if you're interested in doing that, that's one course. If there's something else that you think should be done here, I think that's, did I hear you say you were asking for a motion?
I will.
Okay, so you make a motion, the board seconds the motion is discussed, and then there's a vote. If that doesn't carry, that's one result. If it does carry, then there's another. If it's not that, and you think there's something else, there are ways to pursue it.
Chair Packard, may I address something,
Yeah.
just to correct the record? Director Jacobs' statement is unclear for the public that's in the room. When I said the public would not vote for a consolidation, which is not what we did, what I said was they wouldn't vote for a consolidation because the tax rates were too disparate. So Chino's tax rate's at 325, Central's tax rate was lower. In order to move forward with a legal consolidation of the two entities, those two mill rates would have to be exactly the same. And there's no way that the CYFD taxpayers were going to vote to increase their tax rate and at the same time decrease Chino Valley. So I just wanted to correct and clarify the record. One other point, if I may, Director Steele, or whoever wrote this thing, makes the statement that I said, where the heck was it? Let me get back to that. I just had it a second ago. Where was it? Somewhere under here where I said something that is not true.
Chief, was it the current fire chief believes that the capital board should represent a partnership between the two fire
That's
districts?
it. My statement was the two boards agreed that they wanted a representation of a partnership. That was not the fire chief. Fire chief was simply restating why the boards made the decision. So there's, this thing's fraught with inaccuracies. But, you know, my statements are completely out of context in both the writing and in Ms. Jacobs' statement.
And just to be completely clear, to follow up on that issue, because it implicates this whole analysis, there are all kinds of questions with that. If you go back and take a look at the original documents which were presented to this agency, there was a lot of discussion in open meetings over the course of 18 months about consolidation or merger. My legal advice on the record was neither, because of the difference in tax rates, because there was no way to bring those together in such a manner that it would be fair to the taxpayers of this fire district, for the very reason that you mentioned. That was the actual written opinion that I gave. The only way that we were going to get any kind of the benefits, that is, this agency, of some kind of economies of scale, was to consider the JPA methodology, which has been used by other outfits, not fire districts. First for a fire district, not necessarily for other things. So the whole
Attorney
point-
Cornelius, basically what I'm hearing from you is that you're not going to entertain or agree to go to the vote to the people so that they have a say on their fire district.
Not my decision.
And what you're saying also is that you found a loophole in the law.
No, ma'am, I did not.
Okay.
Director Jacobs, do you think our taxpayers, the taxpayers in the audience, are you willing to pay $75,000 to vote on something that doesn't require a vote?
Where does $75,000 come
That's
from?
what it costs for an election.
Well,
I'd like to remind everybody that due to the 2010 census, state law said that Yavapai County had now exceeded the number that was for 3 county supervisors, and we had to go to 5. Now, there were multiple battles on how the districts were redrawn so that there could be 5 districts. But after that, that had to go with the vote of the people, and there was no difference in any taxation issues at all. So I find it extremely difficult that the state of Arizona would allow this to go on with the disparity there is between the 2 taxing districts, that this could only complicate itself in the future as, like Black Canyon City, Mayor, other fire districts that are up against their limit are drawn in, and we become the cash cow for even more districts. There has to be something wrong with that, and that's my final comment.
Is there a motion?
I'd like to make the motion that our position paper be accepted as read and authored by both Director Jacobs and myself.
It is accepted, it is read.
What specific, point of parliamentary procedure, what specific actions are you requesting of this board?
My motion would be that the board vote on whether they accept the premise that this is in some respects an invalid organization. CAPMA is an invalid organization because it has never gone to a vote of the taxpayers in the respective districts. That would be my motion.
I second that motion.
Discussion? Director Zurcher.
You know, I was starting to research this quite a bit, and I'd like to read a bunch of stuff that I found in my paperwork that, you know, a lot of people in this room, you know, received well over 2 years ago. And I'm just gonna, you know, read it if I may. This is called The Blending of Chino Valley Fire District and Central Yavapai Fire District into one agency analysis and recommendation. The recommendation of senior staffs of both fire districts is that Central Yavapai and Chino Valley Fire Districts enter into an IGA, Intergovernmental Agreement, to form a fire authority with start date of July 1, 2016. From what I learned in my training as a fire district, director when we went down to training in Glendale, is that that's one of the monumental things that a fire district does, is enter into IGAs. A third option would be a joint powers authority. In terms of options, the options were continuing under the current JMA at the time, a merger, a full legal merger, and a third option was the JPA, Joint Powers Authority, in which 2 fire districts create a third party that takes over the operations of the individual fire districts. There are a number of options for appointing fire authority board members. One option is to have even numbers appointed from each fire district board. For a 5-member fire authority board, each fire district appoints 2 members. The 4 fire authority board members then choose a 5th member from either CVFD or CYFD fire boards. Another option is to base the number of fire board authority board members on geographic size and or population. With this option, the larger, more populous fire district would have 3 persons appointed. Once approved by the Fire Authority Board, the individual fire district boards would meet to approve the Fire Authority budget. As separate legal entities, CVFD and CYFD would not only retain their separate tax rates, but also their individual FDAT, which is Fire Department Assistant Tax dollars. Under a joint powers authority, 2 legal entities divest their operational and administrative obligations to a new overreaching third legal entity, the Fire Authority. The mechanism that creates this third entity is an intergovernmental agreement, or IGA. In this case, CVFD and CYFD still exist as taxing authorities. However, a third agency, Central Arizona Fire Medical Authority, becomes the employer. The employees of the 2 entities are transferred to the new entity. Chino Valley Fire District and Central Yavapai Fire Districts, respectively, would no longer have employees. The individual fire districts retain taxing and bonding authority based on previously established geographic boundaries. In addition, the fire districts retain the responsibility for electing board members. The administrative staff of the fire authority handles all financial transactions related to those fire district elections. A fire authority does have a clause or pathway for dissolution. However, once combined, it is very difficult to separate the two. As with anything, we do not enter this arrangement with the idea that we will not be successful. The benefit of this arrangement is that under a fire authority, the mill rates may remain separate and both agencies retain their FDAT dollars. As you know, relates to the budget, budgetarily, I know a draft budget at the time was done. This was done by combining the projected budgets for CVFD and CYFD after factoring the cost savings from combined healthcare savings, workers' comp savings, PSPRS, actuarial savings, and cost avoidance. The JPA budget is shown to be less than the combined budgets of both departments as separate entities under the current JMA. That's all I have.
Director Wasserman.
I have no comment.
Attorney Cornelius, do you have any further?
I think that there was complete and full disclosure, contrary to Director Jacobs' suggestion that, quote, I found a loophole, close quotes, or that there were material misrepresentations or omissions. There were none. All of these things were disclosed in black and white over the course of months. The directors had an opportunity to review it. It was presented to multiple local organizations, including the County Board of Supervisors, state legislative personnel, the county, let's see who else, the county treasurer's office, PSPRS. I think copies went to the AG's office. I think copies went to, who else did the presentations made to, Chief? I mean, how many different parties got
So
presentations?
we were just thinking about that, and if I may, if I may, we're talking about, I understand what you're trying to get to, that maybe this entity is not legal in your mind's eye, and for both of you. But understand the ramifications of what you're insinuating here, because you're basically saying that PSPRS and their in-house AG council, which was present at a meeting when we met with Director Smoot, also agreed that the JPA was a legal entity. You're talking ASRS, Arizona State Retirement System, is also in coercion with us. You're also talking that the Yavapai County Treasurer's Office, who directed our IGA towards the Yavapai County Attorney's Office with Sheila Polk, is also in coercion with us because they created multiple accounts. Collusion with us because they created multiple accounts under the JPA, and in fact issued warrants. In other words, we can actually have a credit line through this organization. You're also talking about the elections department, the assessor's office. You're talking about the Arizona Department of Revenue, not only the taxing entity itself of giving us a actual Arizona income tax ID number, but also you're talking about that the TPT, transaction privilege tax, is stating that we are not a legal entity, but yet they gave us one. You're also talking about that the child support that we all pay, unfortunately I do, is also recognizing us, and the clearinghouse, and the courts. So I just am kind of baffled a little bit because we're not talking about just this agency. We're not talking about just the statute that is affecting this agency. We're talking about statewide agencies and countywide agencies that are all supportive of this organization, and that they are all, as you stated, basically being duped by a loophole. And I am a little bit shocked that all of these agencies, which we vetted literally a year and a half, and in fact, when we even went before ASRS, we had to go before the Social Security Administration as well and talk to them about becoming this JPA. So there's multiple governmental entities that have had to vet this process out and recognize us as an actual subdivision of the state of Arizona before they would issue us tax ID numbers, privilege tax numbers, et cetera, et cetera.
Title vehicles, title real estate.
Well, if I may interject, a lot of these organizations you've mentioned would probably no more than a clerk rubber stamping it because it looks like it's been approved by some public official with a law degree. Now, just let me remind you of what most of the statements we made tonight included. We are unsure that the 10 fire district board members have the authority to enter into this agreement without conducting the election to get the approval of property owners in both fire districts. That's the basis of our argument. Okay? Where we don't have a lawyer representing us now to compete with you, Mr. Cornelius, okay? Or what's been established. We know how the votes have gone in the last year. And I have the feeling myself that this needs further vetting, if not going to a higher authority. I'm not saying as it is, like I said, we're just questioning this, okay? We're not calling you thieves, liars, or otherwise unreputable people, okay? Because we know you're not. Thank you.
But again, for clarification, Nick, we have every legal authority to enter into IGAs, correct?
Yes.
That's one attorney's opinion. That's all you're hearing.
That's not just one attorney's
It's
opinion,
not one
sir.
attorney's opinion.
This was actually, again, training, Glendale, this year. This was another attorney presenting, and he also said that one of the fundamental things fire districts do is to enter into IGAs. This is not
IGAs.
his opinion, not just his opinion.
But we're talking about the joint power agreement, okay, which is different than the IGA, okay?
And IGA created the JPA.
Actually, the joint powers agreement is the IGA.
Yes.
The actual
Well,
document which was
I
signed.
think we made it very clear on where we stand with this, and I don't think we're going to resolve it tonight based upon your legal interpretation, so.
And let me just be clear, because you
But
keep.
there is no semblance of CYFD Fire District or Chino Valley Fire District. There is no fire truck with a name on the side. There's no personnel under our budget that says we are still a fire district and the taxpayers have still a voice on how their money is going to be spent. That's the point that I'm bringing up. There is no fire district except the taxpayers from CYFD and Chino vote for representation on CYFD and Chino Valley Fire District. That is the only semblance we have besides passing up the money. And yes, we did have input on the budget, but as you know, I did not agree with the budget and I voted it down. It's one thing to vote on the budget, to pass the budget, but then to see how people are spending it and not have input on that. And I've told you before that even in the white papers, and I've read this before in front of CAFMA with the call to the public, that all board members, and it was written down, Cornelius, you put it in there, that we would have input at each meeting.
And you have, at everyone. Everyone you wanted to speak at,
Okay.
you've had the opportunity to have input. I think what I'm hearing from you is you're not getting your way. That's different from
No,
having
I think the
input.
taxpayers,
It's not the taxpayers, it's board members. Let me be clear, Director Steele mentioned one attorney. I haven't set up all the JPAs in this state. I've only set up 2. There are other attorneys that have set up several. There's another attorney that set up another fire district JPA. And in fact, I was requested to provide a copy of this particular model. There are changes, but the JPA statute has not only been applied in the context of this agency as a fire district, Copper Canyon on the other side of the mountain, and North Valley down in northwest Phoenix, which now has multiple parties. They have other counsel that have represented them and worked on those matters. So it's not just one lawyer. But, as I said, there are legal methodologies, and you can certainly pursue them.
you also told us that this was a new animal and we can make changes as we go.
And I think if you make a motion and the board approves them, then there they are.
All right, Chief Freitag, you had something to say.
I'll hold. Thank you.
All right, I want to remind the board that we, Central Yavapai Fire District and Chino Valley Fire District, we are still a taxing authority. That is our whole reason. Okay. Director Jenkins, you made the motion for the original agreement, and Director Steele, you are one of the signers on that document. I assumed you both understood what you were agreeing to back then.
I was misunderstood, or I misunderstood the agreement, and I didn't realize the ramification until we passed this last budget for July 1st for fiscal year 2018, and I realized, when I realized that after passing this budget as of fiscal year 2018, that we were going to be the cash cow for CAFMA, since Chino Valley Fire District, unfortunately, is at the state mandated limit for their taxing authority. And that sent off all kind of alarm bells with me. So it's either legal or it's not. And I think we need a higher authority to rule on that, because I think the taxpayers of Central Yavapai Fire District are being taken to the cleaners on this, and would be more so were you to bring in other limited fire districts into the authority. So that's what I'm thinking of, because I'm working for the taxpayer as well as providing the necessary funds for the fire department to do its excellent job.
Are there any other comments?
Madam Chair, I would just like to reference again the combining projected budgets for CYFD and CBFD after factoring the cost savings from combined healthcare savings, worker comp savings, PSPRS, actuarial savings, and cost avoidance. The JPA budget is shown to be less than the combined budgets of both departments or districts as separate entities under the current JMA. I have had conversations with staff. We've had an independent third-party certified public accountant and auditors review the books. Numbers I know and presentations will be forthcoming, but we are saving taxpayers money.
Pardon me, but that's why we agreed to join with Chino Valley in a joint agreement, an IGA, if you will, to share the administrative costs, share the costs, because we were without a fire chief. We had a wonderful presentation by our current fire chief, and we agreed to take that mix and have that umbrella of an administration that would save the taxpayers of Prescott Valley, Central Yavapai Fire District money. That's why we joined. Now are we supposed to give it all back? Because of the higher taxing ability, the higher net asset value of the property in the Central Yavapai Fire District? Are we supposed to give it back and also contribute to future additions to this consortium? I think not. I think the taxpayers would stand on their ear if they knew that was the case. And they're going to have to find out about this one way or another.
Chief Freitag.
No comment?
I'm not going to comment on this.
All right.
Just one last one. There are no current consolidations or mergers before this board with any other entity, and none have been proposed during the course of my time working for this agency. So I'd say since 2012.
Cornelius, I've heard you mention on more than one occasion that possibility.
It is a possibility, but nothing is planned, no discussions have taken place, there are no documents, nothing has ever been presented to this board.
Any further discussion?
I'd like to just, once we vote on this, can we not discuss this for the foreseeable future and then pursue the correct legal course? Because I'm tired of hearing this malarkey month after month after month after month. And quite honestly, I just want to move forward. This organization has and is continuing to do great things on behalf of both fire districts. And I'm just tired of hearing the malarkey, and I just want this to be done finite. Can we do that tonight?
All right, there is a motion on the floor that the board declare this organization invalid. Is that correct?
Can you reread the
Okay.
motion?
Reread the motion, please.
Nobody's saying that it's invalid. Who's
Motion
coming up
that the
with
board
that?
accept the premise that Kaufman is illegal because it never went to an election. And that was seconded by Jacobs.
That they never went to the election of the taxpayers to make a decision if they wanted to do that.
Motion as amended.
It's not to say, and I'm not saying that it's illegal. I'm just saying the taxpayers have the right to vote.
So let's be clear. Please make the motion again.
She's the one that made the motion.
No, you made the motion.
Tom did.
What is the course of, what is the action that you wanted to take tonight?
I wanted to have the board accept the proposition that we presented, that there is the possibility, due to the fact that the taxpayers of the two districts have not approved this, that the creation of CAFMA needs to be re-examined.
Suzanne, or,
Can you simplify that? It's.
Just
I think it's
what
true.
she says.
I'd like to make the motion that our recommendation that the foundation for creating CAFMA may be flawed and that it ignores the vote of the people.
can we do this in a roll call vote, please?
Yes.
Oh, do we
There
have a-
hasn't been a second.
Oh, do we have a second?
I'll second that.
All right.
I'm sorry, could you reread that? All the other motions are withdrawn. Could you read the current motion on the table?
I don't have it typed.
We have.
See, this is the problem with our minutes.
I have a recorder
You-
for backup.
Okay,
We have
thank you.
recorder for backup, and
Thank
we'll
you.
have to listen to that. What he said both times was not the same thing.
Right,
So what we
Sharon.
typed the first time is not the same thing that he said the second time.
I make the motion that the origin of CAFMA be re-examined.
Is there a second?
I'll second that motion.
May we have a roll call vote?
Madam Chair, just a question. I don't think the motion does anything. It re-examined by who,
We've already
when.
discussed it, so there's.
Are you asking for a third party to be hired? Are you trying to get, I don't understand exactly what the action would be.
I can understand your concern, Jeff. And not being an attorney myself, I'm at a little loss to state this in any simple terms, other than the header on the paper, which is quite extensive. Make the motion that the JPA creating CAFMA should be examined by the Attorney General's office of the state of Arizona.
I don't think that the motion will be enforceable because I have asked both in writing, by email, and telephonically, and they've refused, and because two District 1 representatives submitted that request in writing as of May, and as I understand, there has been no response.
That's because they sent it to the Solicitor General, not the AG's office.
As I understand, it was submitted to the Attorney General's office. The Solicitor General is based in the Attorney General's office. The
Yes, I'm
Solicitor
aware.
General would not review such a thing. They handle matters related to appeals. So it would have gone through the office and made its way to the Attorney General.
But the motion is asking that request be sent to the Attorney General. If the Attorney General chooses not to act on it, that satisfies the motion. We certainly can't control what the Attorney General will or will not rule on.
I've done that on several occasions.
That's already been done on several occasions.
Before the entity was put in place, I was requested to do that by the then sitting board, and I made that request. I was advised that the Attorney General's office would not opine because they do not represent fire districts.
If I may, Director Steele, in terms of your motion, I think what you're wanting to get at is that you'd like to move to implement changes that are set forth in this document. Correct? Specifically with regard to questions of validity and board size, et cetera. Is that correct?
That was only a portion of it, okay?
I think that's what, basically, if we can be a little bit more detailed with the actionable item, that would be better for parliamentary procedure in terms of what is, what actionable things you're looking to do. You're looking to implement changes that you've outlined, that you and Director Jacobs have outlined in your brief or letter, and specifically as it mentioned, validity, board size, et cetera.
Director Steele, can I ask Attorney Cornelius for clarification?
I was going
Attorney
to,
Cornelius,
let
can
me
they do
withdraw
two
my-
motions?
I think they can, but let's let them get through one.
Okay, well, I just wanted to know because Director Steele said it didn't address all of it, so I wasn't sure if maybe Director Steele could make two motions under this item instead of just one motion. Might help clarify things.
I will withdraw my motion because I'm getting a little on the wired up side on this, so if you can.
So I'm going to make a
Director-
motion. My motion is that the fire board takes in consideration the recommendation and changes to the joint power of agreement that we have set forward in this meeting as a document for our board meeting today. And as it outlined, some of the items in here that we've outlined is what we would like to have recommended changes.
Is there a second?
Second.
A roll call vote, please.
I just have a question, because I want to make sure, I want to know exactly what I'm voting for, make sure I satisfy. I've read this,
So what
considered it already. You're asking for, I'm not clear on what the outcome would be, just a yep, we considered it?
Well, that increase the board size, go to the vote of the public. These are all of the things that we're looking for in this joint power of agreement recommendation of changes. That's what we're asking.
Okay, so
For the board to approve this as recommended changes that we can bring forward.
Point of parliamentary procedure, then what I would recommend, and I think what the chief was getting at, I think we need to take each bullet point as a separate motion.
I think, if I may,
We'll be here all night.
yeah, it could be done separately, but I think it could also be done
As a document.
as a document.
And that's how we
That
run
these
it,
are
as
the
a
requested
document.
changes, and this board can vote whether it wishes to consider implementing those changes. Really what that means is that the board agrees it wants to implement those changes in open discussions with Chino Valley as to whether it's agreeable to those proposals. And they haven't seen this, hasn't been provided to them. So basically, I think a yes or no vote, does this board want to consider changes to the PA as suggested by Director Steele and Jacobs?
A second.
I think, well,
30 seconds.
All right, are we ready to vote? Roll call vote, please.
And the clerk can administer that, or staff can administer that?
Suzanne.
The clerk should.
Yeah, the clerk should do it.
Director Lawson.
Apologize, would you please read the motion?
The motion is, excuse me, that the fire board take into consideration and recommendations on the JPA that we have set forward in this document and recommendations that have been outlined in this document.
Thank you.
Motion made by Jacobs, seconded by Steele.
Thank you. Director Steele,
Yes.
Director Jacobs,
Yes.
Director Zercher,
No.
Chairman Patrick,
No.
and Director Wosowitz is a no also.
Okay, motion does not pass. have one more item of new business, and that is discussion and possible action regarding the board meeting location. Director Steele, I believe this was your concern.
Well, I thought we had discussed the fact that it was going to be held, the next one in rotating, this one would be going, December meeting would be in Chino Valley, but we would have to decide on a time and a date. That's my recollection of the last meeting.
Also, I think that there was a mention that we were concerned about being out in the cold at Chino, and I think that some people were indicating for a period of time, we should have all of our meetings at this location, because when we go into executive session, the people in the audience aren't going to have to stand outside, and other board members that are not privy of that executive session as well.
Chair Packard, if I may.
Yeah.
We do have, and I've directed staff to accommodate folks inside. We do have the engine bay available at 61 where we could, should the board choose, put chairs. But in order to move the location, if this board votes to do so, we will have to call a special session of CAFMA for the December meeting. We'd have to call a special session of CAFMA in Chino because it does, we can't just move one meeting, we have to move all three.
I'd like to throw out another option because I know 61 might have some limitations in the future with construction. I'd like to throw out the possibility, and again, this is just for discussion because I know we'll have to discuss it further, but that we meet at Chino Valley Town Hall.
We can certainly visit with Chino Valley town staff and see if that's a possibility.
All right. Do we need a motion?
I think just instruction to staff to pursue these other opportunities or options to address the concerns raised by the directors.
Okay.
Okay. Understood.
All right, I will entertain a motion to adjourn.
So moved.
All in favor?
There's a
Second. For a second?
Second?
All in favor?
Aye.
Aye.